So now we have 5 Second Amendment cases that have been sent to the Supreme Court for them to consider. So let's talk about these. But real quick before we jump into this video, if you think that our government needs to stop infringing on our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, and that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. I also want to let you know that this content is powered by the Firearms Policy Coalition, so head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So in this video, we're going to be talking about 5 Second Amendment cases that have now been distributed to the Supreme Court for conference for them to consider whether or not they're going to review these issues. So the first case we're going to talk about is the ANJRPC v. Bruck case. ANJRPC v. Bruck is a case challenging the state of New Jersey's magazine capacity restrictions. Essentially, in the state of New Jersey, like other states, they say that you cannot have magazines that hold more than 10 rounds. They define those to be large capacity magazines, and therefore they ban their possession, importation, buying, selling, etc. of those magazines. So in June of 2018, New Jersey passed Assembly Bill 2761, which banned the possession of firearm magazines with the capacity to hold more than 10 rounds of ammunition. The New Jersey law required owners to modify their magazines to permanently reduce their capacity, destroy them, or to turn them over to authorities. Well, in August of 2018, the district court denied ANJRPC's motion for a preliminary injunction, applying what is known as the failed two-step analysis. This analysis claims that the core of the Second Amendment pertains only to the need of oneself to defend themselves within their home, and that any exercise of gun rights outside of that core, being self-defense within the home, is less important and therefore can be more easily infringed upon. So now this magazine capacity restriction challenge has found its way up to the Supreme Court, and this challenge, a writ of certiorari, was filed seeking Supreme Court review, and now this case has been distributed to the Supreme Court for conference on September 27th. Now the question presented in the ANJRPC case, which is relevant and which the Supreme Court will be reviewing, is whether a blanket, retrospective, and confiscatory law prohibiting ordinary law-abiding citizens from possessing magazines in common use violates the Second Amendment. The second question is whether a law dispossessing citizens without compensation of property that was lawfully acquired and long possessed without incident violates the Takings Clause. So those are the two questions that are presented in this magazine capacity restriction case, and this has huge implications to not just the state of New Jersey, but other states as well, like the state of California, which have magazine capacity restrictions. So the next case we're going to talk about is Russell v. New Jersey. And this is another challenge to a concealed carry permit scheme that a state has, here the state of New Jersey. The state of New Jersey reserves the right to determine on a case-by-case basis whether citizens have sufficiently compelling reasons to exercise their right to carry handguns. Mr. Russell in this case lives in Pennsylvania and was applying for a carry permit in New Jersey because he spends a lot of time in New Jersey visiting his girlfriend. The basis for him wanting a permit in New Jersey is that he claimed he had issues with his ex-wife physically attacking him in the past, and they had issues with his ex-wife and his current girlfriend, so he believed he needed a firearm just in case to protect himself and his girlfriend. And like I said, ultimately the Superior Court denied his application for a permit because they stated he failed to establish that he had compelling reasons to need a permit in New Jersey. After that denial, he appealed that decision all the way up to now where we're at with the Supreme Court. Now there are two questions presented in this case. The first question presented is whether the Second Amendment protects the right to carry arms outside of the home for self-defense. The second question presented to the Supreme Court is whether the government may deny law-abiding citizens their exercise of the right to carry a handgun outside of their homes by conditioning the exercise of the right on showings of need. So this may sound familiar because this is pretty much in line with the New York State Rifle and Pistol Association v. Corlett case, which is a challenge to the state of New York's carry permit scheme. And that has actually been granted review by the Supreme Court, and there will be oral arguments in that case on November. The third case is the Young v. Hawaii case, and this one is quite different from a lot of the other cases because this deals with open carry schemes. The state of Hawaii requires a permit for someone to be able to carry a concealed firearm or also to carry an open firearm out in public. However, a permit has never been issued for either concealed or open in the state of Hawaii for over 20 years. So essentially, although there are open and concealed carry permits that are available in Hawaii, Essentially, Hawaii just does not issue them, so that has led to an outright ban on carrying firearms out in public in the state of Hawaii. Mr. Young challenged this scheme pro se initially before the district court, which means on his own, he didn't have an attorney, and the district court denied and dismissed his case. He then appealed that determination up to the Ninth Circuit, and a 3-judge panel in reviewing the case did find that the Second Amendment does protect an individual's right to carry a firearm open out in public. That decision was heavily rooted in history and tradition surrounding the Second Amendment, and that decision was primarily determined and decided on the fact that the Ninth Circuit has already ruled in the case Pena that an individual does not have the right under the Second Amendment to carry a concealed firearm out in public. So they looked at the precedent, they looked at the history and tradition in the United States, and they determined that if an individual does not have a right to carry a concealed firearm out in public, they must then have a right to carry a firearm open out in public because they have to have some way to defend themselves out in public. Of course, the state of Hawaii did not like that determination, and other states within the Ninth Circuit didn't like that determination. So then an en banc review was sought in the Ninth Circuit. An en banc review is a review by a larger panel of judges in the Ninth Circuit, 10 randomly selected judges, and then the chief judge. In reviewing this case, the en banc panel in the Ninth Circuit reversed what the 3-judge panel had said, and ultimately what they determined is that under the Second Amendment, an individual does not have a right to carry a firearm out in public. The question presented to the Supreme Court in this case is whether the Ninth Circuit erred in holding in direct conflict with the holdings of the First, Seventh, and DC circuits that the Second Amendment does not apply outside the home at all. The second question presented is whether the denial of petitioner's application for a handgun carry license for self-defense violated the Second Amendment. The next case we're going to talk about is Weber v. Ohio, and this case primarily goes to the type of analysis that should be applied to issues that involve an individual's right to possess and have a firearm within their home. So the facts surrounding this case is that Mr. Weber's wife called 911 at approximately 4 o'clock in the morning. She reported that Mr. Weber was in possession of a firearm and was intoxicated. Because of this, Mr. Weber was charged with using a weapon while intoxicated under Section 2923.15 of Ohio's Revised Code. This is a misdemeanor offense carrying a possible penalty of 6 months in jail and or a $1,000 fine. The question presented to the Supreme Court is, what is the proper standard of constitutional review of law that impacts the core value of the Second Amendment, possession and use of a firearm within the home? This is important because although Heller said that your right to possess and use a firearm within your home for self-defense is within the core of the Second Amendment, and Heller has outlined what the analysis should be, some lower courts don't follow what Heller said and they use a different type of analysis, and sometimes they apply intermediate scrutiny like the state of Ohio did in this case. Now, the last case we're going to talk about, which has been distributed for the Supreme Court to review, is Roundtree v. Wisconsin. And this deals with what Second Amendment rights does a nonviolent felon have under the Second Amendment. So the facts surrounding this case is that more than 18 years ago, the individual here, Mr. Roundtree, pled guilty to 2 counts of failure to pay child support, which is a nonviolent crime under Wisconsin's laws. And the issue is Wisconsin actually finds that the failure to pay child support for over a certain amount of days is actually a felony. Over 12 years later, police found Mr. Roundtree in possession of a revolver and ammunition within his home, which he said he kept for self-defense. Ultimately, the state charged him with, and he had to plead guilty to, a single count under Wisconsin's firearm possession statute, essentially because the state of Wisconsin said that he is a felon, and because he's a felon, he cannot be in possession of any firearms. In the lower courts, he brought an as-applied challenge to his conviction, asserting that the application of the statute to someone in his circumstances violates the Second Amendment. The Wisconsin Supreme Court reviewed this issue, and over 2 separate dissents not only denied him relief, but it also denied him any meaningful as-applied review to this statute. So now this case has found its way up the Supreme Court, and there are some questions presented, so let's look at these. The first one is whether a nonviolent felon may bring an as-applied challenge to a state law that permanently denies Second Amendment rights to anyone convicted of a crime denominated as a felony. The second question is whether in adjudicating a nonviolent felon's as-applied challenge to a state dispossession law, the reviewing court may uphold the law without analyzing the particular nonviolent felony of which the challenger was convicted. So those are the 5 Second Amendment cases that have now found their way to the Supreme Court and have been distributed to the Supreme Court for them to consider. And they will consider all these on September 27th of 2021. And this is important because it's a kind of an interesting time period to see how aggressive the Supreme Court will be on Second Amendment issues going forward. As of right now, they've granted review of 1 case, so we will see if they take on multiple cases or if they're only going to limit, as of right now, their review of the Second Amendment just to the Corlett case. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It signals to YouTube that you guys see value in these videos in this type of 2A news, and then it pushes it to more people. Thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. Thank you so much. You guys are definitely fueling these videos, helping these videos to reach more people than ever. And we are rapidly approaching 200,000 subscribers, which was one of my end of the year goals. And it seems like we may reach that goal. So thank you so much to all my old subscribers. And also thank you to all of my new subscribers. And especially if you're a new subscriber, make sure you comment down below that you're a new subscriber and I will make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is with Built by Armed Scholars, and this nation will be maintained by Armed Scholars.